when I am negotiating a contract, it's quite often that the indemnification clause doesn't even seem to be read. So I get very few red lines back on it. But my view as a former litigator who actually tried a couple of indemnification cases to judgment, these are actually really super important clauses.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Eric Drittel, General Counsel at Roostify, tears down Microsoft's online subscription agreement. He gets into the indemnification clause and the other sections that might undermine it. We talk about using clear language, making sure you don't get tied up in long-winded litigation, and staying afloat when IP is at stake. This is a great breakdown of one of the most potentially contentious sections of an agreement. So, let's tear it down. Hey everybody, welcome to the Contract Teardown Show. I'm Mike Whalen, hanging out with smart friends like this guy, Eric Drittel. Eric, how are you today?
Mike, I'm doing very well, thank you. And you?
It's still 2020, so what the freak. Today, guys, we are going to share a document with you and tear it down. It is this one. It is the Microsoft Online Subscription Agreement, and specifically, we're going to go down to the indemnification clauses, which are found in a section called Defense of Claims. So, Eric, here's what I want you to do to start us off. Tell me why this section matters. When are we going to see it? Why should lawyers care?
So you'll see an indemnification clause in almost every contract, and I think lawyers tend to insert them just as a pro forma matter without oftentimes understanding what it is they're asking for or why they're even asking for it. And when I am negotiating a contract, it's quite often that the indemnification clause doesn't even seem to be read. So I get very few red lines back on it. But my view as a former litigator who actually tried a couple of indemnification cases to judgment, these are actually really super important clauses, both from the seller's or licensor's perspective and the buyer's, the licensee's perspective. You see, the clause that we're going to talk about today is in the Microsoft agreement, which is a tech license agreement. So we'll talk about a lot of things that are applicable to tech license contracts and agreements. But all of them are really equally applicable to a construction contract, a service contract. All the same principles really apply.
Well, we're going to go through the different language, but we're going to start with just the title of this document. I found this document, for a legal document, surprisingly easy to read. The fact that they called this a defense of claims, so if you guys are looking at the document, it's down in 5. Defense of claims versus using the language that's common. Does that strike you? It just struck me as interesting.
It does strike me as interesting because a number of companies have endeavored to make contract language simpler. And by making it simpler, you have less of an opportunity to argue about whether there's an ambiguity in a contract. Right. So, for example, Microsoft refers to themselves as we, they refer to the licensee as you, and it's that kind of easy familiarity, I think, makes this a very easily readable contract. It's also a fairly short contract, right, relatively speaking. I looked at others in preparing for our show today, and there were some that were 20 plus pages long, yeah, and didn't fundamentally say anything more than what Microsoft says.
Yeah, so this one's about 10 pages, and we're going to start with that defense of claims. It is still a legal document, so we can still parse the language. Under A, it says defense. It says we, being Microsoft, will defend you, being the licensee, against any claims made by an unaffiliated third party that a product infringes that third party's patent, copyright, or trademark, or makes unlawful use of its trade secret. We like this? We don't like this? What do you think?
I like this actually very much, although we can talk about it, we can parse the aspects of it. So first of all, why is Microsoft offering this? And when you look at this, what Microsoft really wants to do is defend the paternity of its IP. So if a third party makes an IP infringement claim, the licensee has absolutely no incentive to defend that. Right. And what Microsoft is really the one with the incentive to defend. And you'll see sprinkled throughout this is language very similar to that, which shows the intent of Microsoft to defend the paternity of the IP. So that's pretty important. Now, Microsoft says we will defend. And depends on the state you're in. If you say that I will indemnify you, some states, indemnification automatically includes defense.
Right.
Other states, defense is a completely different obligation. So what Microsoft is saying here essentially is they will defend, but they're also going to say, they're saying they'll indemnify as well later, using different words but meaning the same thing. So that's pretty important that Microsoft will defend. Now, an important point here to note, again, depending on the state law that governs, excuse me, the indemnifying party, Microsoft in this instance, can either defend as the claim is brought or wait until the resolution of the claim to defend.
Right.
And so if you're a small licensee, Microsoft's got all the power, you don't. What you, especially if you don't have the financial resources, what you want is the defense to be when the costs are incurred for defense. So you'll oftentimes see language saying, we will defend you for these various claims as incurred. And I think that's a pretty important point from a licensee's perspective, that you want to have the defense of the claim as incurred. So that's pretty important. Next part here is unaffiliated third parties. Now, I would say half the indemnification clauses I look at have that language or don't. Again, in some states, oddly, you can have indemnification between the contracting parties for claims one brings against the other. And that's never made any sense to me. I think it's more appropriate that the indemnification be for third-party claims. And the fact that what Microsoft is doing here is qualifying that as saying unaffiliated third parties is important. It's saying that a subsidiary of yours or a sub-licensee of yours perhaps can't bring a claim, but a third party who asserts ownership of the IP rights could bring that claim. So that's important language. And then what Microsoft says is that we'll indemnify and defend you for any claims that patent rights are infringed. Now, I've been practicing law for, I won't say how long, it's been a long time. And when I first started practicing law, we were always told 100% of the time, never indemnify for patent infringement. And that's because in the US, at the time, the law was the first to invent. So the patent went to the first to invent as opposed to the first to file, which is like the rest of the world. However, U.S. patent law has changed over the last few years, and now U.S. is also a first to file jurisdiction as opposed to a first to invent jurisdiction. So if it was a first to invent jurisdiction, somebody could sit on their patent rights, not do anything, see Microsoft's come up with something and file. Meanwhile, Microsoft would have indemnified for that claim that they could have done a patent search and found a clean patent and just kind of blindly stumbled into an indemnification claim. But now, like I say, the last 20 years or so, it's pretty common for the licensor to indemnify for patent infringement. And again, it goes back to protecting the paternity of the IP.
Yeah, it sounds like they're using pretty modern language to talk about, this is a pretty updated contract. It doesn't sound very copy-pasty. They do go over some licensee obligations right after that, but let's jump down to the limitations because I think it puts the constraints on this thing. They say our obligations in 5A will not apply to a claim or award based on any customer solution, customer data, non-Microsoft products, or your combination of the product with or damages based upon the value of customer data or non-Microsoft. So if you're blending, 3, your use of Microsoft trademark without our consent, and then also your redistribution. And it talks a bit about free products. So they put a lot of constraints on this thing. Is this the right way to format this to you?
Yeah, this is actually pretty standard. If you make modifications to a Microsoft product, Microsoft is actually saying that their indemnification won't apply to the extent that the claim is based on the modifications. So if you've modified something and the modification causes the claim, then you don't get indemnification for that.
Right.
And the same thing with what's referred to in 2 as use in combination. If a Microsoft product standing alone doesn't infringe, and your product standing alone doesn't infringe, but the two together infringe, then to the extent that combination caused the claim, then Microsoft is saying we're not indemnifying you for that. Those are really corner cases. You typically don't see that very often, that something like that actually happens in the real world. But nonetheless, it's pretty good draftsmanship to have the language in there like that.
Yeah, I like jumping down to remedies in C. Some of these qualifications they put on what they'll do for you. It says that if you get this claim under 5A, that make it so you can't use the product, we, Microsoft, will seek to obtain the right for you to keep using it. Or modify or replace it with an equivalent. If it's not commercially reasonable, we might just terminate the rights to use the product and then return any advance fees. That sounds like a pretty nice remedy to have in there.
So that's an interesting one. That's one, if the indemnification clause is ever negotiated, that's where I see actually a fair amount of negotiation. This remedy is referred to as repair, replace, refund remedy. So I'll either fix it so you can continue to use it. I'll pay the third party a license fee so you can continue to use it. That's the repair. I'll replace it. I'll swap out something that is non-infringing with something that swap out the infringing product for a non-infringing product. Or if all else fails, if it's not commercially reasonable to do otherwise, then I'll just refund your money. That's where a lot of people have an issue on that refund piece. The repair and replace is not objectionable. It's the refund piece that creates some problem. So if I'm relying on the Microsoft product and Microsoft simply wants to choose to exit that product and refund my money, that's oftentimes a pretty hollow remedy. But because of the way patent claims, in particular IP infringement claims, tend to go, they go on forever. And it's very common when an infringement claim is brought, it can take months for even the accused party, in this case Microsoft, to even determine whether there's a valid infringement or not. So you probably, as the licensee, have a lot of notice as to whether there's indemnification or not, or whether you're going to get a refund or not. And so oftentimes what I'll see is I think it's somewhat uninformed licensees will say that within 30 days, you have to make the remedy available, which is absurd because, again, it's going to take a year to 18 months for Microsoft to do all the things it would do to determine whether there's an infringement or not. So 30 days is way too short a period of time. And then the refund piece is also potentially challenging.
And it sounds, as you mentioned, the length of time that it takes to sort these things out. If you look in D under obligations, they point out that you got to give the other side sole control over the defense and the settlement, and then you got to help in defending the claim. And then it talks about the party providing the protection will reimburse the other party for out-of-pocket expenses and pay the amount of the final judgment or settlement. You made the point, this could take years.
That's right. That's right. One of the indemnification cases I litigated, I believe, went about 5 years from the time of the claim till we finally got to court. So that's not uncommon to happen.
So would you shift these obligations for some kind of interim support while that's happening?
Well, as long as they're not yanking the product out from under, no. I think that this is perfectly appropriate. And what I'm looking for as a licensee, what Microsoft is offering, I think, is both commercially reasonable and something that actually works for both of us quite well. So it's not something I would typically want to negotiate. And then, as you've already referred to, the obligations in D, the obligation to tender the defense, that's pretty standard. It says you have to notify the other promptly of a claim. Again, the law in some states is that, and you oftentimes see in an indemnification clause, the obligation to, within 10 days, 15 days, 30 days, tender the defense of the claim. And you'll also see language that says, and if you don't tender the defense within the time provided, then our obligation is waived. First of all, that I've never seen anybody's obligation ever get waived because, again, as the licensor, you want to defend the paternity of your IP. Right. Therefore, if it's on the 16th day and you said you had to tender the defense in 15 days, you're not going to say, okay, I'm not liable any longer. So that doesn't make any sense. And then again, in some states, failure to timely tender the defense only reduces the amount of the indemnification by the extent to which the indemnifying party is prejudiced by the late tendering of the defense. So let's play the scenario out. If I'm like, if you're the licensor and I'm the licensee, and I get a claim and I spend a year defending that claim and make some careless admissions and things like that, that make it harder for you to defend the claim, then the chances are that whatever damages I'm entitled to, whatever indemnification I'm entitled to, would be reduced by the amount that, for example, I made admissions that caused the damages to go up. So it's to the extent that you were prejudiced by my untimely tendering of the defense of the claim is what will usually provide you with some sort of out. Microsoft, interestingly, doesn't use that language here. They just say you have to promptly tender the defense. So I think that that's quite common. Giving the sole control, again, is very often the case. One thing you will see from time to time is the indemnified party will have a right to appoint counsel of its own as co-counsel or to oversee or whatever, but at my expense, the indemnified party's expense. And we have no right to make admissions or do anything. It's just really to monitor the status of the case. You see that every so often, especially in high stakes indemnification claims, but I don't think that's, it's the language here again is quite common. And then one of the things that's in here that I really like from a licensee's perspective is reimburse the licensee for reasonable out-of-pocket expenses. Oftentimes, the agreement is silent on that. Or I've seen some, in fact, I looked at one even recently, which says that the indemnified party has to pay for its own costs of helping the indemnified party. Did I say that right?
The indemnifying, yes.
The indemnifying party
Right.
has to pay its own expenses of cooperating with the indemnified party. So this is pretty good. This is pretty upfront and says that we will pay you, and so it's all the right language. Now, remember earlier I mentioned in that first paragraph in 5A talked about the costs of defense. So here's now where they say in D2. Where they will pay the amount of any judgment. So that's the indemnification piece. Again, they've never used the word indemnify here, but it's very clear from that language that they are not just defending, but they're also indemnifying.
Well, I want to talk about the relationship of a couple of other sections with the indemnification piece. And the first is the limitation. This is down in 6. And it talks about the aggregate liability of each party for all claims under this agreement. It's limited to direct damages to the amount paid under this agreement for the online service during the 12 months before the cause of action, provided that in no event the aggregate liability for any online service exceed the amount paid for that online service during the subscription. Then it talks about for free products, that's capped at $5,000. How, I mean, that seems like a low number relative to what this claim could become.
It certainly would be. But for an exception they've created. So the language here is, again, fairly common, that there's a limitation of liability. 12 months fees is a very standard amount that you cap liability at, that they're even throwing in $5,000 for free product is, relatively speaking, generous. 5,000 doesn't sound like much, but when it's free, standing up for the product is still pretty good. But what they do is they say that the limitations of liability do not apply to claims under parties' obligations under Section 5, the Defense of Claims or Indemnification Clause. This is really well written. This is saying that so the cap on liability does not apply. The exclusion of damages doesn't apply to indemnification claims. So whatever the costs of defense are, whatever the damages are that are owed, Microsoft's saying, despite the limitation of liability, we're paying that. Now, this is one that I do see also negotiated fairly often. And sometimes it's because of really terrible drafting. So sometimes you'll see in an exceptions to limitations provision, something along the lines of, except for breaches of confidentiality or indemnification.
Right.
No, so a breach of an indemnification clause. So if somebody is really parsing the contract and you get a judge or a jury that's reading just the literal words of the contract, the only time the exclusion would apply in that case is if there was a breach of the indemnification clause. That's not what you're looking for the exclusion for. What you're looking for the exclusion for is the obligations under the indemnification clause. So what Microsoft has done here is exactly what I would be looking for, saying not requiring breach first, but just saying the party's obligations under Section 5 give an exception, and the damages are potentially uncapped. This is also often negotiated because I do see from time to time not typically in IP infringement indemnifications, but indemnification for other types of things where somebody will want to put a cap. So as an example, there are a lot of contracts today that involve the processing of data for a third party. You and I enter into a contract, you give me your customer's data to process. If I have a data breach, what's my obligation to indemnify you in that instance? It's a very common clause you see in a lot of contracts these days. And so if there were a data breach and I'm processing your data, the liability could be in the tens of millions of dollars for a very low value contract. So as the processing party, as the party who ultimately would bear potentially that liability, I would typically want to see the indemnification capped at some multiple perhaps of the fees paid. So it might be 5 times or 10 times fees paid. But the indemnification exclusion here in the Microsoft agreement, as it applies to the IP license, is perfectly appropriate and one that would, in my view, pass without objection.
Well, before we talk, sort of the general principle from this in closing, I want to give you a chance to talk about the relationship between this section and the warranties section, which is
Sure.
back and forth. We won't read it, but give me your thoughts on the fact that we've got both indemnification and warranties. Does that tell you anything?
Yeah. So Microsoft again has done a good job here. What a lot of drafters do, and I think it's somewhat sloppy, is they both want a warranty of non-infringement and an indemnification. And in my view, you really should be entitled to one remedy, not two. So this is oftentimes coming from the licensee. The licensee says, I want you to warrant non-infringement, and I also want an indemnity for non-infringement. So it gives potentially two different claims. The warranty claim would be capped by the limitation of liability, whereas the indemnification would not. And as the licensor, I want it clear where the licensee's remedy lies. Because under the warranty clause, if the licensee is going to make a warranty claim, there's no obligation to tender the defense and all the things that, as the licensor, protect the licensor and enables the licensor to guard the paternity of the IP. Whereas under the indemnification clause, all of that is there. So as the licensor, I will say to the customer, you pick one remedy, you get one, not both. And I try to steer them to the indemnification because it's not capped by the limitation of liability. And I would say in most cases, not all, but most, when the licensee understands that they're getting a better remedy under the indemnification clause, they really don't need that warranty of non-infringement. It's something that's been in lots of clauses for years and years, and nobody pays any attention to it. And I think it's actually worthwhile paying attention to. So I would exclude it and go under the indemnification clause exclusively.
So in terms of drafting and wrapping up, what's the principle here? Is there something that we can draw from this? Do you like this document overall?
I do. I do like this document overall. I think from a licensor's perspective, it's a very good document. From a licensee's perspective, it's likewise a very good document. As I said earlier, I think that one thing from a licensee's perspective that could really improve this is the obligation to defend as costs are incurred, not let Microsoft wait till the end. But in reality, it's not a hill I would die on.
Right.
Because I think that Microsoft would, without a doubt, want to defend immediately from the moment a claim is brought. I think one other piece of language that could possibly improve this, and I hadn't mentioned this earlier, but there's no real definition of a claim except it's a claim brought by an unaffiliated third party. Sometimes I as the indemnitor, I will want not just indemnification for actual claim that is brought, but also for a threatened claim. So I've seen this actually in the past where I've gotten a cease and desist or some other communication from somebody who claims to be the owner of the IP. They don't file a lawsuit. They just have sent me a threatening letter. And we have that question, okay, is this subject to indemnification or not? Should I tender the defense of this or not? Or do I wait till I'm sued? So I think just for clarity's sake.
What notice requirements do I have, right? We're supposed to timely notify them. Is that when the letter happens?
Exactly.
Yeah.
So in the couple of times this has happened to me where I've gotten the demand letter or something from the party claiming ownership or some right to the IP, I've just tendered the defense. Right. And nobody's ever argued saying, well, you tendered it too soon. So I think that could clean up the language a little bit. So I think overall, Microsoft did a nice job here. It's a well-written contract and something that honestly, I think most business people could understand without having to engage the legal department to have to parse what does this mean. Right. So that's always a good thing.
Well, I can guarantee you, we have a special kind of nerd who's watching this show right now. If those people want to hang out with you and just talk indemnification all day, Eric, what's the best way to reach out to you?
So you can reach me by email. I'm General Counsel of Roostify. You can reach me at edratell, that's EDRATTELL, at Roostify, ROOSTIFY.com. And I'd be happy to exchange information, touch bases with people. I can nerd out about this all day long.
We're a special crowd. And if you are the special kind of nerd who wants to learn more about this stuff, please go over to lawinsider.com/resources. We'll have the information with this contract and some links for you, as well as getting in touch with Eric. And if you want to be a contributor on the Contract Teardown Show, just email us. Just go to community@lawinsider.com. We'll connect with you. Thanks to you guys for watching. Thank you, Eric, for hanging out. We'll see you guys next time.
Bye-bye.